There appears to be serious problems for prosecutors in a high-profile Tampa murder case. Richard McTeer faces the death penalty for allegedly throwing his girlfriend's baby out of a moving car. Fox 13's Warren Ellie explains McTeer's attorney says the state has no proof that it all went down the way prosecutors say it did.
You throw a baby out the window.
It's a dirty game.
Richard McTeer may have sounded like he was owning up, but months later, his lawyers say there's no proof he tossed 3-month-old Emmanuel Murray out of a car. The baby was found dead along the interstate. His mother, Jasmine Bedwell, told police McTeer attacked her at her apartment and threw the baby onto concrete before driving off with the child.
Of course, the question is, can they prove that McTeer had the baby in a car and actually threw it out the window? McTeer's attorneys think not.
That isn't anything that's supported in the facts or the evidence of this case. Matter of fact, there's not a scintilla of evidence that suggests that.
According to the defense, no one saw McTeer leaving the apartment. No one saw him driving a car.
There's no testimony that Mr. McTeer even is the owner of a car. There's no testimony that he arrived at the original scene of the crime in a car. There's no testimony that exists that he left the scene in a car. There's no testimony that he was ever in a car that night.
It may leave prosecutors with only circumstantial evidence to win a death penalty case.
You can prove a case circumstantially. It doesn't have to be through direct evidence.
Attorney Roger Futerman says circumstantial cases can be strong, demonstrating, for example, that McTeer had the time, opportunity, and motive to toss the baby.
I'm sure the state is putting together a time frame and some circumstantial evidence because there are different ways to prove it.